Good evening. Welcome to today's meeting. This is a public meeting and members of the public and press are permitted to report on the proceedings. Reporting includes filming, photography, making an audio recording and providing commentary on proceedings. Please note this meeting is recorded and streamed live. The recordings are published on the relevant meeting page of the Council's website. By choosing to attend this meeting, you are deemed to have given your consent to being filmed or recorded and for any footage to be broadcast or published. If the alarm sounds, the premises must be evacuated immediately. Do not spend time collecting personal belongings. All emergency escape routes are clearly signed. Once you have left the building, the assembly point is in the High Street opposite the Guildhall. Members and other speakers are reminded to use their microphone when speaking. So, turning to the agenda, item 1, appointment of substitutes.
There are no substitutes this evening, Chair. Thank you.
Thank you. No substitutes. Any declarations of interest? No? Okay, thank you. Public participation, I don't believe there is any. We're whizzing through this. Minutes of the last meeting. So if we go through it page by page, anything on page 1? Page 2? Yes, John.
Just one item under number 27. There's a list of 4 complaints, 3 of which were no action and 1 was under assessment. And I just wondered what happened to that one.
Sean.
Sorry, was the question what happened to the 4th complaint?
Yes, under assessment. So when was it assessed and what was the outcome?
If you bear with me, I'll come back on that before the end of the meeting, if that's okay.
Thank you, John. Page 3. So, shall I sign the minutes or shall we wait for that?
Just sign them at the end.
Sign them. I'll sign them at the end, okay. Thank you. So item 5 is the Local Government and Social Care Ombudsman Annual Review Letter.
Thank you, Chair. Yes, members will be aware that one of the functions of the Standards Committee is to monitor the amount of complaints that are referred to the Local Government and Social Care Ombudsman relating to Worcester City Council and the proportion of those that are upheld. So every year the Ombudsman publishes an annual review letter looking back at the outgoing year. So the committee is receiving, because the committee has not met for a little while, the committee is receiving the annual review letter that relates to 1st of April 24 to 31st of March 2025. The annual review letter and the information on the Ombudsman website contains benchmarking information from which the committee, if you want to look at the Ombudsman website, you can see the kind of amount of activity that typically happens at a district council level in relation to complaints, at an upper tier unitary council where there's more social care complaints and so forth. And you can see some trend information on their website. What we provide in relation to our report is, to the extent that it's available, the trend information that relates to Worcester. So there's a table in the report that reflects Ombudsman complaints referred and upheld or not upheld since 2016 to the current or the outgoing year. So you can see that 1 complaint upheld is in order in terms of our trend information. We'd had typically either 0 or 2, and a number of years ago we'd had 5, which was due to some performance issues in a particular service area, which was subsequently dealt with. In relation to why we had 1 complaint upheld, that's actually the next matter on the agenda. So, you know, I appreciate these reports are really quite brief, but the point is the Ombudsman publishes our profile, so therefore it's available data for anybody to scrutinise. And 1 upheld complaint is, we would suggest, is is within the normal range for both the City Council and district councils generally.
Okay, thank you. Has anybody got any questions around that? Okay, so item 6, reports of the Local Government and Social Care Ombudsman.
Thank you, Chair. So this report is, as I say, dealing with the period since the committee last met to the present time to acknowledge what complaints have been received and referred to the Ombudsman. There's been one upheld decision, as referenced in the previous item. It related to a decision taken at committee in relation to a pump track, and the upheld decision of maladministration was related solely to the amount of time it took for council officers to reply to the respondent in relation to this aspect of her complaint. She had other aspects of her complaint. There was a judicial review pre-action protocol, other matters were in train, but the corporate complaint aspect the finding was that officers were slow to respond. The complaint also included complaints that the relevant committee, it should actually say Place and Economic Development Committee, didn't follow the correct procedure, and the complainant also alleged that members had not declared relevant conflicts of interest. Those matters weren't upheld by the council's internal investigation, and the Ombudsman didn't uphold those aspects either. So the Ombudsman's decision solely related to how long it took to give the ultimate response to the complainant. Before the Ombudsman had looked at the matter, the council had apologised for the delay, and because there was no remedial action or change to the decision that was made, the Ombudsman found that there were no further steps the council should take. So that's that complaint, if that's okay, Chair.
Thank you. Any questions around item 6? No, I've got one question, and that's just to enquire what processes are in place to track complaints.
Thank you, Chair. We've got a system called IdeaGen. It's an automated piece of software. It's looked after by our policy and strategy team. It schedules, dates received, dates due. It sends reminders. And our officers also assign complaints, personally to heads of service, directors, etc. And they chase us up for responses as well. So it's not just an automated system; there's the chasing that goes on as well. I think this one was a little bit different because it was bound up in an ongoing judicial review pre-action correspondence. But nevertheless, we accepted the point that the complaint should have been twin tracked at the same speed. But the process for tracking and making sure that things don't fall overdue is, as I say, both the human approach and the software approach to make sure that we don't fall into any patterns. As you'll know, we're a very lean staff team now, so the complaint workload is, albeit they're not regularly upheld, is a significant workload. And we have to try and share the investigation of complaints amongst a number of senior staff at stage 2 to try and make sure that they're properly done. A stage 2 investigation can end up being quite a long report, and we've made sure we try and share those out amongst service managers, heads of service and directors.
Okay. Thank you, that's interesting. Is there anything more the Standards Committee can do to assist with that, with the process?
I don't think so, thank you, Chair, but I think it's the trend information that's of interest because, it's a few years back, but we did have a cluster of complaints that related to a service area, and the Standards Committee asked officers to account for that, and that did lead to service improvement. So I think, I'm not going to suggest it's ever good to have any upheld complaints, but it's that spike, I think, in complaints that you can look at. Once or twice there's been an individual complaint that relates to perhaps a change in national policy, and there was one that related to, a couple of years ago, related to the condition of private sector housing properties and I suppose damp conditions that can lead to mould. And the Ombudsman's finding there was around whether at the first stage the council had exercised a discretion over its enforcement powers, or it properly had a duty and it should have done more. So was the caseworker right to close the file when they did, or should they have done more? And what we noticed was that was a theme that they were looking at, if you like, thematically around the country. And I think it was, they published a public interest report around that. That led to a service improvement here and elsewhere about our enforcement policy, making sure that that was really clear, that at stage one we will always do these things, we may do these things, you know, discretion versus obligation, and making sure that the policy was really clear for complainants. So I think those are examples of where the process does add value, whether that's the Ombudsman or the Standards Committee, just challenging a little bit more and saying, well, what are the changes we've made in response?
Okay.
I think that's where the value can be added.
Yeah, okay, thank you. Any further questions on that point? Yes.
Yeah, I was reading the complaints process that basically says complaints against Worcester City Council. Does that process apply to councillors as well, that time scale? Because it's two days to acknowledge and then a full response or holding letter presumably within 15 days.
Through you, Chair. It's a separate complaints process for councillors. It's also published on our website. It's the procedure for the assessment of complaints, and the initial assessment should be completed within 20 working days.
Councillors as well, that time period?
Do you mean complaints against councillors?
Yes.
Yes. Yes.
Yeah, thank you.
Yeah.
Thank you. Any further questions? Okay, so item 8, complaints made under the Members' Code of Conduct.
Just skip the annual report of the Standards Committee.
I'm sorry. Annual report of the Standards Committee, item 7.
Thank you, Chair. Because this is a regulatory committee, we consider it to be best practice. In fact, the sector considers it best practice for there to be an annual report that goes up to the full council. So the committee will be familiar with this. This is what we do with the planning committee as well, and the audit and governance committee. So it's a look back at the outgoing year and the work programme of the outgoing year, such as it was. The report obviously acknowledges who the members of the committee are, and this is obviously, again, the only committee where we have additional representation, which is excellent. We have parish council representatives, we have our independent person, Ray Needham. So we have a committee that stood up, available with capacity if there is standards business to transact. And I guess in an ideal scenario, there isn't. In most years, a lot of business to transact, and that reflects a healthy position, largely. The report obviously reflects, if you like, the sort of statutory role. So the Monitoring Officer under the Localism Act is given some specific statutory responsibilities around ethical standards, upholding those, the initial assessment of complaints, providing legal advice to the council, providing advice and guidance to the parish councils in relation to ethical standards if required, convening training and so forth. So that's explained in there. Ombudsman complaints, we've obviously just talked about what that process is, and the previous year, 23-24, there were no upheld complaints. Code of conduct for members. Members will recall the Worcestershire Code of Conduct was adopted a couple of years ago, so we're operating with that. We have a member champion for civility and personal safety. I think that's reflective of across the chamber, Worcester City Councillors' commitment to civility in the city and so forth. And I think, you know, we've appreciated having the member champion roles come forward. In a committee system, you don't really necessarily have that same visibility as if you would in a cabinet model. So I think member champions adds some value to that process. We've also amended a number of sections of the Constitution over the last couple of years. One of those was the Protocol on Member Officer Relations. So that had been adopted in March 24. Complaints had been assessed under the Code of Conduct. A number of complaints are assessed in every given year. Typically, because of the narrow scope of the code, you know, a complaint has to be when a councillor is acting in their capacity as a councillor, discharging their functions and duties on behalf of the City Council. Typically, a number of complaints are screened and assessed against the published criteria, and they fall outside of the code, or there's a recommendation that informal action is the appropriate way to resolve those complaints. And that informal action might be an apology, or it might be some sort of, you know, sort of conversation or mediation or recognition that words of advice will be provided. In Worcester, again, this is fairly typical. There isn't a common theme to the complaints, but some of the headings are regularly referred to: respect, lawfulness, selflessness, and repute. So none of those complaints pass the initial assessment stage, and if they don't meet the test that there is potentially on the face of it a breach of the code, then they don't make their way to a hearing subcommittee. So it's, you know, it's a sort of a peacetime scenario. It's, again, sort of a good news story. I suppose if I might respond to that point about the complaint that was outstanding when the report was last published, Councillor Renshaw, I wonder if that might be the one that referred to a comment that was made that was potentially disrespectful but wasn't intended to be disrespectful. I'm limited to what I can say in the public domain, but the remedy there was an apology that was given at the start of a subsequent committee meeting, just for the record, in the event that any offence had been caused. So again, it was a marginal sort of informal action. In the event that any offence had been caused, it would be wise just to make an apology for the record. Thinking of the timescale, I think that's probably which that one was. So then, yes, and then so finally the report recognises obviously that there are obviously obligations on members and officers to declare gifts and hospitality in accordance with the Nolan principles. De minimis low-level gifts and hospitality do not need to be declared, higher instances do. We also recognise that member training is really valuable, and we had done a refresh of the induction season when we reconvened as a full council in 2024, and we had excellent attendance from members across a range of training for the 6 months that followed that initial election period, across a whole range of training aspects. When we had a local government association peer review this April, I don't know if anyone remembers reading that peer report, but they were very complimentary about our governance at Worcester. They met a number of members, and they saw our training records. They felt assured that, and they saw the attendance record at committees, they felt assured that members were very committed to attendance, training and development standards and so forth. So the write-up that we had in the LGA's assessment was complimentary about the governance of the council and the commitment that members make to that, and officers supporting them. In fact, we should have probably referred to the LGA findings in there. If it's helpful, there is a quote I can put in if that would be helpful. There weren't, I don't know if you remember, but from the LGA's findings, there weren't any governance type recommendations back. The only one perhaps that's adjacent to this was to have another look at the member officer protocol and make sure that service response times are realistic and can be honoured. I mean, that's not technically a standards issue, but that was the only kind of governance-y type one that came back. Yes, and so that's the look back at the previous year. Thank you, Chair.
Thank you. Has anyone got any questions? Councillor Lamb.
Thank you very much. This is a question more for Sian. Clearly, we haven't met in a year, and politics moves on very quickly. And without going into the specifics, because I suspect this is one of the items that might be considered by the Standards Committee or a subcommittee at a later point, can you just remind us of the sort of, when it comes to freedom of speech by councillors, because I think we all know there's a lot of discourse going on social media at the moment about various issues that have been prevalent in Worcester over the summer. And obviously from previous meetings, you know, councillors have got enhanced protection of freedom of speech under, I think it's Article 10 of the Human Rights Act. Can you just sort of remind us of that? Because I think it's really important at this moment where we all know what's going on in the news and in social media at the moment about what councillors can and cannot say, and you know, lots of legalese is being thrown around about councillors making libelous, slanderous, defamation characters. So can you just remind us the power that councillors have when it comes to freedom of speech in carrying out their role as councillors, both in the chamber, in committee, and also in social media in the public as well? Because I think it's really quite useful, bearing in mind what's been going on over the last sort of few months here and across the country.
Thank you. Yes, through you, Chair. Yes, I'm happy to do that. What I would say is that there's some live issues at the moment being under initial assessment. When those are concluded, I do think it would probably be helpful for something to be published on our website as there's a sort of statement, a clarification, because it is a subtle legal framework. So for tonight, what I will say is if we separate out for a minute an allegation of defamation and acknowledge that that would be made by one individual against another individual, and the City Council wouldn't be involved in that. That would be if I thought if you thought, let's put it the other way, you thought I defamed you, that would be a separate matter to a code of conduct or, you know, a freedom of speech matter. The local authority, therefore, wouldn't get involved in those sorts of accusations, and we wouldn't be able to provide advice or support to an individual who was on the receiving end of that, kind of in their own capacity. However, where a complainant thinks that somebody is acting as a councillor in expressing themselves, even on social media, and they take offence by those comments, then they could use the code of conduct and are using the code of conduct to say, well, I think that breaches the principles of respect, for example. So the first part initial assessment is to consider whether that person is acting in their capacity as a councillor. And then secondly, to consider if they are those principles of the code engaged, and also how does the Human Rights Act impact on them? Because it's exactly as you say, Councillor Lamb. Article 10 is a freedom of expression. All rights under the Human Rights Act, as you know, are qualified rights, so they are subject to the rights of others. But a councillor's Article 10 rights of freedom of expression are enhanced. In other words, they're expected to raise issues of public interest and discourse, participate in those debates. That may be inside or outside of the chamber, as long as they're doing so respectfully and as long as it doesn't become personal against an individual's personal characteristics, bullying and harassment or Equality Act, then they do have quite a high bar. Of course, that freedom of expression works both ways, doesn't it? So often a party that's aggrieved by freedom of expression has also benefited from it in the past. And I think we see quite a lot of that now on social media, and it gets quite heated quite quickly. But you're absolutely right to say there is an enhanced level of protection. There has to be reasonable belief. There has to be, people still need to act reasonably. There is a legal framework. There is case law to consider. I won't say too much tonight, but there is obviously external legal advice available, and every individual complaint is assessed on the facts, because what might apply globally to one situation might be different to another depending on exactly what was said in a particular social media post. Yes, the code is ultimately subordinate to the Human Rights Act and that freedom of expression principle.
To come back on that very briefly, I mean, it's very unlikely now we're going to get a fresh intake of councillors before Worcester City Council is wound up. But I can imagine this would be a perfect case study, because we have had this situation, when I think the council was elected on the same day, we said, oh, we're going to have some, in the same way we'd have planning training and licensing training, we'd also have some training on standards. And I think we all did it as part of this sort of induction, isn't it? And I think this issue would be a perfect case study, because if you're a new councillor, you know, and you're not versed in politics law or whatever it might be, and you come in just because you want to do the best by your community, you might not know that councillors do have slightly, they can't just say what they want, as you say, everything's conditional. But it would just be worth telling people that, you know, as a councillor, because this is something in the present day that councillors do come up against a lot, and I think sometimes councillors need it to be kind of clarified where they stand for their own, because otherwise there might be a chilling effect, mightn't they? Councillors may feel that they can't express views, they can't say what they feel because they feel, oh my God, I'm going to end up, you know, with a sort of lawyer's letter or whatever. Anyway.
And of course, it is, we are in operation for another couple of years. So if people thought it was valuable to have another seminar to perhaps focus on freedom of expression, social media, we can most definitely put that on, and Beth Evans would happily deliver that, you know, on that sort of online session, if that would be helpful. I think, you know, some of it is subtle, and I think case studies, exactly as you say, they can kind of test the edges of that, can't they? So we obviously, it's no trouble at all, and if people would be interested, and we tend to have quite good take-up for standards training, don't we? So if people think that would be helpful, we can certainly get that put on, with a focus perhaps on freedom of expression and social media perhaps.
Thank you. Councillor Pingree, I think you've got a question.
It's not a question, it's just a comment, which was to say how much I've appreciated all the training that's been put on this year. It's been really high quality and it's been really useful, so I just wanted to give my thanks for that. It's great. And I look forward to future training on social media and yeah.
Thank you. Any other comments or questions on item 7? Okay, so moving on to item 8, complaints under the Members' Code of Conduct.
Thank you, Chair. Yes, and members will be aware that unless a complaint is upheld following a standard subcommittee meeting, it won't be published. And therefore, the report that's always provided in the public papers for a standards committee is necessarily quite a brief summary of if you like, the workings on this process. So therefore, I appreciate there's not a lot of information you can extract out of this. I suppose what I would say was that the amount of complaint activity in the council is typically at a low level, and then very recently there's been a spike in activity, so that we've gone from 3 complaints to now 11 complaints. In fact, I think as we right now, we're possibly at 12 complaints. So that isn't a typical year for us, and that reflects a particular bubble of activity that's going on, and I'll just leave that there. You can see in terms of outcomes, again, it may be the case that a complainant very much wishes something to be within the scope of the code, but if the assessment is that it isn't, then there is nowhere else you can go with it under the code, and the code is narrow. And in instances where an aspect might be within the scope of the code, it may not be a breach of the code, or the best outcome may be informal resolution. So there's not a lot here so far to discuss in relation to those complaints within this year. The other thing I would say again is, though, typically there isn't trend information except around the principle of respect, and that perhaps is the principle that gets the most traffic these days, I think, under the Code of Conduct. Which is quite interesting when we come on to the next item, where the government is still saying some people don't even have codes of conduct, and we need to make sure that really naughty councillors are dealt with, and we need this and that. We don't have, you know, sort of serious financial irregularities going on at Worcester. Obviously, we don't in any of our councils here. But I think that the level of activity around respect is the increase in that is correlated with increasing levels of activity online, for example. I think it certainly is. And whether that calms down or not, I don't know. But people are quite entitled to bring complaints. You know, I think at the moment, I don't see any movement from the government to change the framework around Article 10 or social media or respect. So I think a number of times that somebody might reach for the code, they may find it's not necessarily you know, going to give them the remedy that they hope. But that's as far as I'm really able to go, because some of those are still under initial assessment. So thank you, Chair.
Thank you. Councillor Cooks.
You'll be pleased to know I'm not going to ask you any of the details, because I know you can't say any of that. I was just looking at the fact that there's been a bit of a spike, and what the implications are that for just staffing of the council, because obviously we run a very, very lean staff team, and if we're not expecting to suddenly have this peak, how are you managing in that, and what sort of implications are that having? There's a trade-off, so what isn't getting done as a result of it.
Through you, Chair. Thank you for the question. I appreciate what's behind it. We've actually had to take some external advice, which obviously there's a cost implication for doing that. I think it's really important that every complaint is assessed on its merits. The main impact it has is delay. And often myself, or if I've put it out, the independent solicitor who's supporting me, the process will take longer than it should. That's the main implication. And I think often in standards matters, that just adds to the sense of grievance that already exists, and I'm aware of that, and I'm often apologising for the delay. In relation to where there's a bubble of complaints and they are from different people on similar principles, it's important every time. In fact, the independent person, I was just talking about this before the meeting started, every single complaint has got to be looked at exactly on the facts, because every complaint that's coming through is slightly different. So every piece of material has got to be assessed individually. So, you know, it is obviously then just sort of adds to the workload, but you just couldn't possibly cut and paste these, because you would, it's not doing justice to the process. I mean, I think if this level of activity continues, then we would look at some sort of framework for responding, and perhaps, as I say, publish some more guidance on our website ourselves. But for the present time, we're having to just treat them all on their merit. And so my lengthy answer to the question is some external legal advice and a bit of additional cost and delay.
Thank you. Any other questions? Yes, Councillor Cochrane.
Thank you. Just in terms of the process, when a complaint is at the initial assessment deemed to be not within the scope of the code, would the persons named in that complaint be informed that there has been a complaint, even though it's not within the scope, or does that mean that they needn't know about it?
Yes, the subject councillor is always entitled to know, and ideally they know as quickly as possible. Sometimes if it's so obviously can be screened out, then it's better for Ray and I to screen it out and then let somebody know that it wasn't even a thing. But there's a question of I think everyone wants to know if there's a complaint and how it makes them feel. So there's obviously, you know, a natural principle around transparency about knowing if someone's complained about you, I think. But certainly if it's not within the scope, then it can go no further in terms of there's no jurisdiction for it to be taken anywhere else.
Thank you. Any other questions or comments? So are we all happy to note that report? Yeah, okay, thank you. Item 9, government proposals for a new statutory framework to strengthen standards in local government.
Thank you, Chair. Yes, I mean, I think, you know, it's longer serving members of the committee will remember that we've talked about how it would be great if, you know, whichever government was in power sort of had a look at the standards regime again. We've often talked about that. This government have said that they would. However, the changes that they're proposing don't really go to the heart of things in Worcester, because they're saying things like, we will require every local authority to have a code of conduct. Well, most local authorities do have a code of conduct. Most local authorities like ourselves have adopted the LGA one, maybe with a couple of tweaks, but that's been going on in a quite healthy way around the country for the last few years. Right. It also talks about introducing a suspension provision. Well, that is valuable, but you can see from, as I say, the traffic we have around complaints that really we're more in a kind of moderator environment, really, about sort of conversations between peoples, not a scenario where we wish to suspend someone. So as a local authority here, we haven't been sitting around wishing we had a power of suspension. So I'm sure it's welcome for some areas where they feel toothless, where they've got somebody that they can't deal with. But again, that's not really something that we felt would be helpful here. So they've said that they will look at that. I think the other thing, though, that is helpful is the ability to appeal a standards determination. So at the moment, if once the monitoring officer has screened it. If it doesn't pass the initial assessment stage, that's the end of the matter. If it's referred to a subcommittee for investigation, then the subcommittee's finding, upheld or not upheld, is the end of the matter. And the government is saying that it will introduce a right of appeal, effectively, against any determination. What's not clear at the moment is whether that's things that have been upheld, that have been through investigation, or things that have been screened out. And I tend to think that the workload of the appeals body would be overwhelming if every complaint, even the ones screened out, could be appealed. So I think it's probably those where there's been, you know, a committee decision. So again, a fairly higher bar. One thing that is helpful, again, we've, like others, we've moved on it already, but it will be a helpful piece of clarification. The government is saying they will make it, put beyond doubt this ambiguity around whether home addresses have to be published, council home addresses. We've taken the view, as a number of councils have, that as the environment has changed and as councillors have faced more hostility, there's a particular provision in the Localism Act around threats to personal safety. We've relied on that one more and more. We've taken a view on that. Other monitoring officers have done the same. But the government is saying, well, we'll put that point beyond doubt and make it clear that you don't have to publish your home addresses. And I just think, well, I think we've chatted about this before as a previous standards committee. It just feels like a very old-fashioned provision these days. It relates to an era that we don't live in anymore. So obviously we welcome that, and we've always been happy to take people's addresses off the website when that's people's preference in any event. And I think we've also talked as a committee before about whether councillors, you know, want to operate 2 different phone numbers and have a right to disconnect. And we obviously appreciate people come to, because councillors are often doing a full-time job as well, and then therefore they don't feel they can disconnect because they're using their evenings to be councillors and their weekends. But in a scenario where there's more and more hostility out there, I think everyone's entitled to disconnect and have that peace. And also a kind of communication barrier, which is why somebody might want a work mobile phone number and a personal mobile phone number. And those sorts of things that, again, just it feels like where we are now in 2025 perhaps is not quite where we felt we were 10 years ago. So those sorts of things, I think it's helpful for the government to signal that they support councillors in these aspects. The only specific legislative change that's proposed is removing home addresses. But I'm just making that point more widely, that it's part and parcel of that, I guess, yeah, right to privacy, which you still have. You're not expected to be always on. And in the Code of Conduct itself, as I say, using the LGA model template as we did, I don't know if you remember, but there's a provision near the start of that now about, again, disconnecting from unreasonable people and the ability to disconnect if somebody's being unreasonable. It's not disrespectful for a councillor to disengage if somebody's being unreasonable. And the council's also got its unreasonable customer behaviour policy, and we do give people warnings and disconnect. So I think all of those things, and partly in terms of your civility role, it's a kind of a framework, isn't it? A protective framework. I think that's really valuable. So yeah, I mean, I suppose what we're saying in terms of this is it's good that the government is looking. The LGA no doubt will consult with us. If there is a consultation document, we'll bring it here. We can have a meeting to look at it if there's any recommendations of substance that we want to respond on. But at the moment, the fact that they're saying things like, you must have a code of conduct and you must have a standards committee, we sort of go, okay. So there's sort of not a lot to get excited about at this point. There's a reference in here to supporting individuals affected by allegations of misconduct. But again, I think that's when it gets to an investigation level instead of, initial assessment. Thank you, Chair.
Any questions or comments? No? Okay. So we're all happy to note those proposed changes. Thank you. Item 10, Register of Members and Officers' Gifts and Hospitality and the Register of Interests.
Just to note that they're there.
So that's just to note that they're here for your inspection if you would like to. Any other business? I've not been notified of any, no. No, that concludes the meeting then. Thank you, everybody. How quick was it?